Welcome to another Zoom oral argument session of the 5th BCA. As a reminder, we are being recorded and broadcast live on YouTube. We have three cases set for this morning. Our first is case number 20-2201, Philip Dennison versus Halifax Staffing. I'm joined today on the panel with Judge Wozniak, and we are thankful to have Senior Judge Bruce Jacobus sitting with us today. Thank you for joining us.
Thank you. Well, that's the first time on Zoom for me.
Yeah, brave new world.
Yeah, no kidding.
So we have 20 minutes set per side. Mr. Morgan, I'll reserve 5 minutes for your rebuttal unless I hear otherwise. And with that, you may proceed.
Thank you very much. May it please the court. My name is Ryan Morgan, and I'm here on behalf of Morgan & Morgan's Employee Rights Group, representing Mr. Philip Dennison, who was wrongfully terminated from his employment by Halifax Staffing after objecting to Halifax Staffing's fraudulent billing practice related to coding discrepancies with Medicare Medicaid. The issue, as this panel knows before you, is whether summary judgment was appropriate in the lower court when the circuit court ruled that Halifax Staffing was not an employer under the Florida Private Whistleblower Act. That statute defines an employer as any, quote, private individual, firm, partnership, institution, corporation, or association that employs 10 or more persons. The Florida Private Whistleblower Statute is a remedial statute. So like all other remedial statute, it must be liberally construed in favor of granting access to the remedy here. I did want to do a brief review of the facts just to give the panel some bearing. I know this was in our brief as well, but Mr. Dennison,
I think we're familiar with the facts. If you'd like to move to your first argument.
Absolutely. Here, the panel must reverse.
Down, don't you think, between the two cases, O'Malley and Citrus County? I mean, that's really the deal.
Yes, sir. That's exactly where I was going to go. And I throw in a third case. I think to really analyze this issue, the panel has to harmonize the three Florida Supreme Court cases at issue: O'Malley, Citrus County, and Keck. And so I'll take them in chronological order here. And so in O'Malley, we all know there was a Florida statute that created the Florida Insurance Guarantee Association, which was to help.
Do you think that the corporation could be public for some services or some issues and private for others, or is
Absolutely
it one or the other?
The Florida Supreme Court answered that question in the Keck case when they said that a company can be private specifically for labor relations, but be considered public. And in that case, it was for sovereign immunities.
Yeah, right. It was a tort, wasn't it? Yeah, I know what you're talking about. Yeah.
Right. It involved a motor vehicle accident with the Jacksonville Transit Authority.
Right.
And so the law is clear that depending upon statutory definitions, like in the sovereign immunity statute or other statutes, a company can be private for some purposes and public for others. And so really what you get down to, Your Honor, when you talk about the O'Malley case and the Citrus County case, the way that those two cases become harmonized is they're really two sides of the same coin. So in O'Malley, the issue was there was no dispute. It was a public corporation. It was directly established by a Florida statute by the legislature. The issue was whether it was serving the public good. Other insurance companies said, no, it's not. It's in essence doing private interests competing with us. We have to pay money to fund this thing. So the issue was public good in the O'Malley case. Obviously, the Florida Supreme Court held that there was a public interest there because it was aiding citizens who had complied with state mandatory insurance minimums, and yet their insurance company goes insolvent. In Citrus County, you had the other situation. There really wasn't a dispute that Citrus County, that the hospital system served a public good. The issue was how it was created and whether it was actually legislatively created. We all know Judge Polston, who authored that opinion, and the majority of the Supreme Court came down and said, no, it's not legislatively created. It is a private corporation under that contracts clause. There is no act of the legislature that has created it. That also dovetails with the Florida Attorney General opinion that Halifax Staffing got here in this case in 1993 before they had established it, where very, very clearly the Attorney General states, and I want to read it because I want to make sure I get the quote correct here. This is on when it's answering the third question that the Halifax staffing had
Isn't the Attorney
posed.
General's opinion just about as good as yours or mine as lawyers? I mean, is that right? I mean, the Attorney
Yes,
General-
they're not binding, but I would certainly like to think that they are fairly authoritative in a lot of areas here. But what they say is, quote, the act, which is the special act that allows Halifax to create corporations. It says the act itself does not create the not-for-profit corporation.
I mean, obviously, though, the Attorney General opinion dealt with a different definition of employer, right?
Yes.
So shouldn't we be viewing this through PRISM, because this is summary judgment on a action brought under a private whistleblower act, whether any of these cases bind us to the conclusion that Halifax is deemed, or that the staffing company is deemed a quote unquote private corporation? What in the case law do you think helps with that definition?
Sure. To answer your first part of that question, I agree with you. I do not believe there's anything binding one way or the other, because all of these cases do cover different terms of the Constitution or different statutes. So we have to harmonize those Florida Supreme Court opinions, right? And take what
when we're harmonizing, I mean, to the degree any of these cases provide guidance as to the definition of private. When I look at O'Malley, it says private corporations are those which have no official duties or concerns with the affairs of the government. There's also language in Pioneer Boat Line, a 1919 case, that says a private corporation is one formed for the benefit of its stockholders exclusively. So when we look at those two, I mean, very kind of defined definitions of private corporation, how does the staffing company fit within those definitions?
I don't think there's any dispute here that Halifax Hospital and then the staffing company serve some public interest. I'm not going to dispute that. I don't think we can dispute that. But in the O'Malley case and in the Forbes case, what is very important is in that both of those situations, those entities at issue were directly created by the legislature. And then when you read that with Citrus County, so to follow your line of thinking there, Your Honor, if that was just the test, if it's just public interest only, then Citrus County would not have been decided the way it was, because they didn't even.
Citrus County, did Citrus County ever explicitly hold that it was a private corporation, or is the holding only that the contract clause applies to the foundation's contracts?
Well,
I think the Citrus case, if you look, it says issue presented, whether the contracts clause protects a corporation that is contracted with the hospital district holding. We hold the contract clause applies. And the reasoning is based on a purpose of a legislative enactment meant to protect those contracts. So I'm not seeing how that helps us at all with the definition of a private corporation or this act.
Because in that case, it went further on to talk about that. First, we have to back up. Contracts clause that Citrus County was analyzing, that issue only applies to public corporations, right? If they're a public corporation, then that issue wouldn't even be before the court. It would have been decided against the foundation. So there is a public versus private distinction there. And so under that guide.
Yeah, and I mean, I think the rule that was being applied, right, was that state officers and agencies have to presume that legislation affecting them is valid. And so that rule is never really stated in Citrus County, but wouldn't that be the analysis that the court, the Supreme Court in the first DCA in the first instance we're going through?
I think with the operative language here, Your Honor, would be it's page 1107 of that Citrus County opinion, where it states very clearly, Judge Bolson states, the party's representation simply do not alter the fact that the foundation is not a creature of the legislature and is a distinct legal entity from the hospital board, nor do the facts that the hospital board was involved with the foundation's incorporation, previously controlled by its board, and are its sole member, make it public. The Supreme Court is saying, even with all those things, which is very similar to here, they are still private. They are still a private.
As you highlight in your initial brief, or maybe it's reply, O'Malley did not create a bright line rule. To my view, Citrus County does not create a bright line rule. What tests would you recommend us applying? Is it legislative created only? is a public corporation?
I think it's both. I think you have to combine O'Malley and Citrus because they analyzed. I think there's two elements here. It is legislatively created, which is what Citrus County covered, and then it has to be a public interest, public good, which is what the issue was in O'Malley. Reading those two and putting those two cases together, these companies need to have both of those elements to be considered a public corporation under the Florida Supreme Court jurisprudence. Again, that dovetails with the Keck case, which says you can be public or private depending upon the situation. You know, the sovereign immunity definitions, the IRS definitions, all of those are much more expansive because they talk about instrumentalities of the state. And in fact, the sovereign immunity statute specifically says corporations can be instrumentalities of the state. So a much different.
Why is that too narrow of a view of public? So here we have a governmental entity, a special district that pursuant to a statute has formed a corporation. It was not independently formed. It was not formed by private citizens at every level here. We have a public entity forming a corporation. Its board is constituted by public officials. Where does private come in that scenario?
It comes in because it was not legislatively created.
So that's the rule. If it's not legislatively created, it is private for purposes of the private whistleblowers statute.
I would argue yes, because that is one of the two necessary components. And here, you know, again, I'm not arguing that there's not some public interest here. If there wasn't, then we would be arguing that as well. I think if you look at the other way around, and if you're only looking at the public interest, then the policy behind that and kind of common sense will show that that's not the correct test by itself either. Because if that was the situation that you just had to serve the public interest and public good, pick a charity, Coalition for the Homeless, the food bank, whoever it may be. If they create a staffing company to pay their employees as a not-for-profit only to promote their public good mission, then one could argue they now become a public corporation. And I don't think there would be any argument from anybody here that we know they're not a public corporation.
Yeah, and I think that's a good point. I'm just struggling with the three-legged stool here, where we have a corporation formed by a public entity for a public purpose that is staffed or directed. The board is comprised of public officials. We have public. Just because it wasn't created by the legislature, that's where I'm struggling with. Well, it wasn't formed per statute, or it wasn't specifically created by the legislature, although it was created with the legislature's approval. Now, despite those three legs, we're going to pull it out of the public sphere and make it private.
That's why you look at Citrus County, and when you read that opinion, it does make that distinction that the act, the Florida legislature statutes that allows these hospital boards to create these companies and these contracts with them does not mean they are legislatively created. That is what Citrus County stands for. Understanding that's in regard to the contracts clause. Just like in O'Malley, it's not the private whistleblower case. That's a case about, other constitutional protections. So we don't have a case that's directly on all fours. We have to utilize all of the available authority as best we can. That then also relates my point about Citrus to what the Florida Attorney General's opinion said, because it makes sense. The act, which was the act that allowed hospitals to create these corporations, does not actually create the corporation itself. And there is a distinction between there. I understand you. I think it's facially, it's a compelling argument, right? When I was not involved in this case in the underlying action or even on the briefs until in the last few weeks preparing for this oral argument. And so I've tried to come in and look at this from, well, how we have these two cases, O'Malley and Citrus County. Clearly, those are the two main cases argued by the parties. All the research shows that these are really the two main Florida Supreme Court cases on this issue. We can't ignore one or the other. We have to utilize both. It's binding precedent. And the only way to utilize both is to take the lessons from each of them, which is from O'Malley. You do have to have the public interest, but in O'Malley, there was no dispute on how it was created. And then in Citrus County, opposite, no dispute on public interest, it was all focused on how it was not created by the legislature in a strikingly similar factual scenario as to here.
Considering what was pled in this case, is the issue really private versus not private, or is it private versus public? Because what was pled was a private whistleblower action, and Halifax was saying it's not private, I guess, because it's public. But on summary judgment, is the issue really private versus not private?
You're right. I don't think it really is that stark necessarily. It's going to be whether it fits within the definition of the Florida Private Whistleblower Act. As this panel knows, we cited to the Dahl case and the Hutchinson case, which stand for the fact that companies can actually fall under both. You can be sued under the public whistleblower and the private whistleblower one. So, that's an argument. I think that helps kind of put things in perspective, if you will, of the kind of overall retaliation whistleblower makeup of our state. But really, it comes back to, does it meet the definition of the Florida Private Whistleblower Act, which is what was pled here? And now one thing I want to address very quickly is the appellee's argument about that we lost no rights under the Florida Public Whistleblower statute. That's not true. That statute had long run even before this lawsuit had filed, because you only get either 60 or 180 days under that public whistleblower statute. So that's a red herring argument by them meant to distract the panel. The real issue is, does this corporation here meet the statutory definition of the Private Whistleblower Act? Based on O'Malley and Citrus read together, we believe they do. I see that I'm coming up on actually below my rebuttal time. So thank you very much, and talk to you in a minute.
All right, thank you. You may proceed.
Yes, may it please the court, Richard McCray. I'm here on behalf of the appellee, Halifax Staffing, Inc. Let me just, and I think the issue in this appeal is whether Halifax Staffing, which is wholly owned and wholly controlled subsidiary or affiliate of a political subdivision of the state, is a quote unquote private corporation within the meaning of the statute. And responding to Judge Wozniak, I don't think it's a binary choice.
Let me ask you, I mean, it seems to me, what is the difference between Halifax Staffing, Inc., other than the name, and Citrus Memorial Health Foundation, Inc.? They both do the same thing, don't they? I mean, it seems like they're set up exactly the same. Maybe Memorial did more stuff, but it seems the whole purpose of doing that, and the legislative creation of it all was to avoid the Florida Retirement Act. You get sovereign immunity, but you can have private corporate. I mean, it seems to me they're both the same. What do you say to that?
I disagree, Your Honor, for a number of reasons. One, as one of the judges already pointed out, the special act that created the hospital district here granted it the authority to create corporations. That did not exist in the Citrus County Hospital Board case. In fact, the cases say that the hospital board somehow facilitated the creation of that entity. More importantly, here, the special act.
It's a 617 corporation, right?
Yes, that's true. But here, the special act says that any corporations created by the hospital district have to be under the control of the special district. That was not the case in the Citrus County case. And in fact, that's what led to the dispute. After a lease agreement was entered into under Chapter 155, which is intended to allow.
Well, let me ask you this: does the contract clause of the Constitution apply to Halifax Holding or Staffing?
I'm sorry, I didn't hear the beginning of that, Your Honor.
Does the holding in Citrus County about the contract clause of the Florida Constitution, does that apply to Halifax Staffing?
No, there is no evidence in the record like cited by the person.
You can change people's contract, between parties and have no problem with that, I guess.
Well, that issue of whether or not there was some sort of unconstitutional impairment of contract is not here. I'm not here to argue that.
I mean, would it apply to, that's my question is, would that apply to Halifax Staffing if that was the issue? That it was a violation of the contract?
Not if Halifax Staffing is something other than, only if Halifax Staffing is a private corporation. And the Supreme Court has told us there are at least three different corporate forms. One is a private corporation, one is a public corporation, and one is a quasi-public corporation, as stated by the Forbes Court years ago. The only issue in this case is whether or not Halifax Staffing is a quote unquote private corporation and under the meaning of the Whistleblower Act. And if you look at the test in O'Malley, which has been used again and has never been overturned, Halifax Staffing meets every single element of that test. It's concerned with the affairs of government, as its articles of incorporation state. Its purpose is the preservation of public health. And the articles of incorporation said its functions have to be exclusively devoted to that purpose. Halifax Staffing was not voluntarily organized by private persons. And Halifax, most importantly, for reasons I'll get to in a minute, Halifax is bound to perform acts solely for government benefit. This is not only mandated by the Articles of Incorporation, but a political subdivision maintains direct control over its assets and management. That did not occur in the Citrus County case. Finally, the last part of the test is the primary objective of Halifax Staffing is not the personal emolument of its shareholders. Getting to this issue, getting to your question about Citrus County, there was evidence in the record, which is not here. There was evidence recited by the first DCA that the purpose of the creation of the foundation was in order to be able to pursue joint ventures that the hospital district otherwise could not perform. There is no such evidence in the record below.
Is there anything to the holding, well, one factor that was applied in the gun decision from the Middle District, that the staffing company is used, its sole purpose and function is to move people around who would otherwise be employed by Halifax out of the FRS and into a self-funded retirement plan?
Well, let me say this. In the first DCA's opinion in Citrus County, they point to statute 122.061, which says that a special hospital district does not have to participate in the retirement system. It has an election. But once it does, it can't revoke that election. And the implication being clear from the first DA's decision that the hospital board in that case had made that election. There is no evidence in the record in this case to that effect. In the reply brief, Mr. Dennison is trying to stretch the facts in the record to match those in the Citrus County case, but they're just not here. In addition to the fact that that argument was never made below. And you know, as we say in the Centex case, Mr. Dennison should be precluded from making that specific contention because he never made it below. I think the most important distinction is that in Citrus County, the Special Act did not legislatively grant to the board the authority to create corporations. And here, unlike here, there was no legislative enactment that required that any corporations whose creation was facilitated by the Citrus County Hospital Board had to be maintained under the control of the board. In Citrus County, control over the operations of the hospital was passed from the hospital board to the foundation by a lease agreement under Chapter 155. The foundation later amended its articles of incorporation to eliminate the hospital board's right to control the board. That simply could not happen here. Could not happen here. Section 3 of the Special Act that creates the district authorizes the district to establish corporations, quote unquote, under the control of the district. Article 6, Section 3 of the Articles of Incorporation provide that the members of Halifax Staffing's board shall, quote unquote, at all times be commissioners of the district, not just majority control, but all. Section 2 of the Special Act provides that the district's 7 commissioners shall be appointed by the governor. So here, a political subdivision directly controls Halifax Staffing's operations and finances. So the disputes that arose, it could not arise between the district and Halifax Staffing like those that arose in Citrus County. Why is this significant? In Citrus County, because the hospital board did not directly control the foundation, the political subdivision had no right to control the foundation's operations or what could be done with the foundation's assets. More importantly, the absence of such control by the political subdivision meant there was no way to ensure that the foundation would be required to operate exclusively for the benefit of the public. Here, it has to, by statute and by the articles.
What is your response to the argument that if, this public purpose is going to be what this case turns on, that there should be additional discovery permitted?
Well, I think we made that briefly in our answer brief, in that there was never any request made for additional discovery. 5 months transpired between the filing of a motion for protective order with respect to the deposition that was sought of the general counsel, and no effort was made to call that up for hearing or to seek discovery from any other source. No affidavit was filed under the rule 1.510F saying we haven't had sufficient discovery. So I think that would be a belated request that was never preserved. And with respect to the issue of prejudice, I heard counsel say somehow it wasn't too late to bring a claim under the Public Sector Act. Under that act, Mr. Dennison had to file a charge of discrimination with the Florida Commission within 180 days of his termination. This case was filed long after that. So that was an opportunity that was available long before we moved to amend and long before we moved for summary judgment. So I don't know that I have anything else I can add. I'd be glad to answer any questions, but basically, it's not a binary decision, whether it's private or public. The issue is whether it's private. And I think with the facts that are in the record, I don't know whether it's public, quasi-public, but it certainly under the O'Malley decision does not meet the definition of a private corporation, quote unquote.
Any additional questions?
You like Justice Kennedy's dissent, I take it?
Well, we relied on it. I thought it made sense. It did make sense to me that O'Malley and Citrus County could have stopped early on.
What I found interesting was that Chief Justice Marshall weighed in on that back in the 1800s, for God's sakes. Who knew? I mean, really. I mean, it's incredible. All right.
All right.
Thank you for your time and thank you very much.
Mr. Morgan? About a little under 4 minutes remaining.
And I was on mute. Yes, thank you. Try to be brief here. Judge Sasso, I thought you brought up a good point that I wanted to bring up originally and just ran out of time, was about the gun case and some of those other cases where it did talk about in Halifax staffing specific situation. Part of the reason for doing this is to take employees out of the Florida retirement system.
And is there anything in our record that reflects that definitively?
The Florida Attorney General opinion, which was attached to the Deputy General Counsel's affidavit. This was obviously raised by them at the lower court level. It's not something we came up with here in the appeals process. Certainly, we have tried to expand upon our arguments that were made at the lower level, more thoroughly analyzed those arguments. Otherwise, why do you have appellant briefs and appellee briefs? You just get the lower courts the record, and that's it. So it's not a new argument. It is in response to the arguments they have made in regards to that Florida Attorney General opinion, but it does state in there that they are seeking to avoid the payment of those expenses. That relates to also the Citrus County case, because in 155.40, the legislative history of that law discusses the need to privatize. That's the word the legislature used, public hospitals, to better compete, to have to more efficiently and cheaper operate these hospitals. So you have this transition over time from public hospitals wanting to privatize more and more. Now they're saying it's not private. So, that's another contradiction I do believe you have in the appellee's position.
Did your client make arguments concerning the Attorney General opinion in the lower court, the trial court?
No, not at the lower court. No, that was not addressed. It was really the debate between the O'Malley, Citrus County cases. There was a few other cases cited, but that was the lion's share of the argument, like it's been here. One thing I did want to address was Mr. McCrae's his attempts to distinguish Citrus County, and I don't want to rehash all of those. But if you go to the Florida Supreme Court's opinion, those distinctions do not matter. They are not what actually decided that case. in our favor of what we are arguing here, because Judge Polston, quote, stated, nor did the facts that the hospital board was involved with the foundation's incorporation, which is just like here, previously controlled its board, just like they control the board here, and was its sole member, just like here, somehow remove the foundation's contracts from the protection afforded by the contracts clause. Again, that's only for private corporations. So these distinctions that are attempted to be brought up are not what were dispositive in the analysis and the reasoning for the Florida Supreme Court. And unless any of your honors have any questions, I will be quiet. And I thank you for your time.
All right, thank you both. Well argued on both sides. That will be in recess.
Thank you very much.
Thank you.
So we're